वो जो फर्स्ट हाफ का था उसको लिखाने लग गए थे, इसलिए थोड़ा टाइम लग गया। आपका सबमिशन हम लिखा दिए हैं, इसको सीए भी कर लीजिए, 2-4 दिन में आएगा। आप हमको दे दीजिए, प्लेट रिटर्न स्टेटमेंट सब दे दीजिए।
Which was tested before the Supreme Court perhaps. But this might enhance the case. Reported in 2025 SCC online Jharkhand 295.
इसके अलावा एक और जजमेंट, वो नहीं है, एक और जजमेंट।
But is this your option refer to 2013 for SCC page 7?
पैरा 17-18 भी देखिए। Anyways, you will have an order. आप हमको प्लेन रिटन स्टेटमेंट का
But your lordship will also see notes on this, because in this case also, Lord, so far as your lordship has not decided कि कहाँ पे लगेगा, कहाँ पे नहीं लगेगा. Your lordship has said कि exclusion claim there has to be proof, because the Supreme Court also says it has to be proof.
That's
so
right.
Lord, we have given oral evidence to say that it is in continuity.
वो तीनों है ना इसमें?
हाँ,
you will get it back. कोई बात
नहीं, we have the copy.
Okay, you have the copy. इस ट्राइबल एरिया में बहुत इश्यूज है, हिंदू वुमेन्स राइट टू प्रॉपर्टी, ट्राइबल वुमेन्स राइट टू प्रॉपर्टी।
But how can one prove? It is either by village note, which is under section 76.
आप देखिए, यहाँ तो सेकेंड अपील में सब्सटैंशियल क्वेश्चन ऑफ लॉ के समय हम बहुत सारी चीजें नहीं लिख सकते, लेकिन आप गैंगस्टर सेटलमेंट रिपोर्ट देखिए, जहाँ जहाँ देयर इज अ जजमेंट व्हिच आई हैव पास्ड कि जहाँ जहाँ सेपरेट रिकॉर्डिंग है इन द रिकॉर्ड ऑफ राइट्स, राइट, दैट इज सपोर्टेड बाय गैंगस्टर्स रिपोर्ट। वो भी ये वो जजमेंट हमको याद नहीं है। There is a direct judgment. I have given that judgment.
That is in different areas of Santal.
Yes, in different areas of Santals there are different customs.
Yes, that is not.
Wo and also I have also given the judgment if it is separately recorded in the name of the daughters, then under such circumstances, as per gangsters report itself, the customary law of exclusion does not apply. I've held that. I've held it. वो जजमेंट नहीं है।
हमको
देखिए सेकंड सब्सटैंशियल क्वेश्चन ऑफ लॉ है ना, तो हम इतना नहीं लिखेंगे, लेकिन हम उतना होल्ड किए, हम उसको होल्ड किए हुए अभी याद नहीं है कब, ये हम एडवोकेट याद रहता है
आपको वही बताया था।
आई थिंक उसमें वो थे, वो मिस्टर शर्मा सीनियर एडवोकेट है, he was one, Mr. Rajiv Sharma. I think he was there in that case.
I will check.
Call.
Passover date from supplementary 10:30. Item 20.
आपको मिला?
नहीं।
उस वही चाहिए ना आपको?
But the fact of that linkage is different to the fact of.
You are seeking a declaration. आप कौन सा ऑर्डर मिला आपको?
My lord, order in APF filing number 1795 of 2025. Here in this case, one of the clear court cases payable according to the old date that was paid by 50,000. By virtue of the amendment of the Jharkhand Amendment 2023.
हम एक वो भी किए हैं, डिक्लेरेशन वाला भी किए हैं।
इसको कोई नेक्स्ट डेट में रख दिया?
नहीं, आप इसको स्टेट को सर्व कर दीजिए, कोर्ट फीस का मामला है ना, स्टेट को सर्व करिए, स्टेट को सुन के ऑर्डर करेंगे।
ठीक है। दैट टू सर्व द कॉपी टू द।
एक केस में हम लैंड एक्विजिशन एक्ट से रिलेटेड मैटर था, सेक्शन 30 का, तो एग्जैक्टली याद नहीं आ रहा, लेकिन हम होल्ड किए हैं कि एड वैलोरम में नहीं, मतलब एड वैलोरम नहीं लगेगा इन द केस ऑफ डिक्लेरेशन। अब खोजिए, खाली हम ही खोजेंगे क्या बैठकर, लेकिन हम होल्ड किए हैं, हमको पता है ये नहीं।
In my case, the simple fair respect to the declaration of title.
आई अप्रिशिएट
I'm not
दैट।
saying-
आपको जजमेंट भी बता रहे, आपके केस में किए है ना, कहाँ है बताइए।
वो नरेंद्र सिंह
एक ऐसा है
नरेंद्र सिंह
लीजिए, ये है तो नरेंद्र नाथ।
नहीं ना the logical fact.
दिखाइए।
In my case
हम ऑर्डर कर देते हैं, उसके बाद देखिए। फाइलिंग नंबर FA 6902 of 2025 with IA number 1762 of 2026. The learned counsel for the appellant has submitted that office has pointed out a defect regarding payment of court fees. The learned counsel submits that since the suit was only seeking declaration, आपका परमानेंट इंजंक्शन भी है। परमानेंट इंजंक्शन होने से क्या लगेगा?
My lord, that was permanent injunction. I have already paid a court fees of ₹101 before the learned trial. And my lord, I have a judgment of the.
So that will be paid now.
Permanent injunction हम 500 दे सकते हैं, but there is direct judgment on this point, my lord. I would like to refer, my lord.
अच्छा रुक जाइए। The learned counsel has
2007
referred to order dated 9/10/2025 passed in FA filing number 7351 of 2025 and has submitted that only fixed court fees is paid.
of ₹1,000 by virtue of the Jharkhand Amendment 2023.
आपका 23 के बाद का सूट है।
23 से पहले का सूट है।
Just a moment. Since the matter relates to court fees, the counsel for the appellant is directed to serve a copy of the interlocutory application in the office of learned advocate general, along with the memo of appeal, with its enclosure. ठीक है? The state of Jharkhand, the matter, post this case on, बताइए।
नेक्स्ट वीक तक
ये ऑर्डर देख लेंगे, या यहाँ रख रहे हैं, उनको दे दीजिए। FA फाइलिंग नंबर है 7351 of 25। पोस्ट ऑन 11th March। उन लोगों को भी समय लगेगा थोड़ा।
from the daily list at 2:15 under heading for final disposal item 1 WPC 5528 of 2006.
ठीक है, जितने भी रिट पिटीशन है पुराने सब CNT वाले हैं।
नहीं तो कैंसिलेशन जो बंदी कर
कैंसिलेशन वैसे बाय एंड लार्ज हम देख रहे हैं CNT वाले ही हैं। बताइए इसमें क्या कहानी है?
earlier also the private respondent filed requisition before the honorable court. The honorable court has remanded the matter to the deputy commissioner, and deputy commissioner also dismissed my revision, against which also he filed revision before the commissioner, which was dismissed on the ground of limitation. The facts of this case is
Commissioner has dismissed on the ground of limitation.
limitation.
Where is it?
Lecture notes. Annexure 16 page 106.
106.
एडमिशन के बिंदु पर आवेदन की सुनवाई की गई, साथ ही निम्न न्यायालय का आदेश का उल्लंघन किया। सदाली जब तक मंत्र के अवलोकन के प्राथमिक दौरान मुकदमा प्रश्न भूमि ग्राम जुमला के केवट नंबर 3 केवटदार शुक्ला सिंह मुंडा के बारिश होने का दाखिल है। निम्न न्यायालय के द्वारा माननीय उच्च न्यायालय के द्वारा CWJC नंबर स्वयंतु दिनांक स्वयंतु दिए निर्देश
नहीं सुनिए, पता नहीं मन डाइवर्ट हो गया, जरा बार फिर से पढ़िए तो।
ऊपर से
हाँ।
एडमिशन के बिंदु पर आवेदन की सुनवाई की गई, साथ ही निम्न न्यायालय का आदेश का अवलोकन किया गया, सरकारी अधिवक्ता के मंतव्य के भी अवलोकन किया। प्रार्थी का दावा मुख्यतः प्रसंग भूमि ग्राम दुबला के केवट नंबर 3 केवटदार शुक्लाल सिंह मुंडा के वारिस होने पर आधारित है। निम्न न्यायालय उपायुक्त द्वारा माननीय उच्च न्यायालय के द्वारा CWJC नंबर 2117 ऑफ 1995 आर में दिनांक 22/9/1997 को दिए गए निर्देश के आलोक में सुनवाई का मामला निष्पादित किया गया। निम्न न्यायालय का आदेश स्पष्ट किया कि केवट नंबर 3/3 3/2 केवटदार की मृत्यु नवबद्ध हो गई है। केवट नंबर 3/1 केवटदार शुक्ला सिंह मुंडा के मामले के बाद उनके लड़के यदुनाथ सिंह मुंडा मालिक बने। उनकी मृत्यु के बाद उनकी पत्नी धस्ती देवी एवं उनकी मृत्यु के बाद लड़की सत्य भामा भूमि को दखलकार हुई। वर्तमान दखलकार है शुक्ला सिंह मुंडा, पिता दुबराज सिंह मुंडा द्वारा कथित रूप से केवट नंबर 3 के केवटदार तेजपाल सिंह का लड़का बनकर अपना नाम से विवादित भूमि दाखिल खारिज संख्या 11/1963 से ही करा लिया गया। हम लोग को 1963 से जगहबंदी चल रहा। इसके विरुद्ध कुमारी सत्य भामा ने प्रथम श्रेणी दंडाधिकारी के न्यायालय में आपराधिक मामला वाद संख्या 267-69 दायर किया। उस वाद में युवराज सिंह के केरला सिंह के पुत्र होने का गलत पाया गया। तब से विवादित भूमि पर विपक्षी सत्य भामा तीनों केवट पर 3/1, 3/2, 3/3 पर दखलकार है प्रदर्शित कर रही है। निम्न न्यायालय ने उसे उपायुक्त द्वारा प्रथम श्रेणी न्यायालय में 267-69 में दिए गए आदेश का आलोक में अपील खारिज की गई थी। इस मामले में स्वतः का प्रश्न निहित है, गुजारिशों न्यायालय के द्वारा निर्धारण नहीं किया जा सकता। साथ ही प्रश्नगत रिवीजन बाद निर्धारित समय सीमा समाप्ति के बाद दायर की है, जिसे कोई संतोषजनक आधार नहीं दिया गया।
तब जाके सूट फाइल करिए ना, वन फाइल ये सूट।
कुछ और
ये लॉन्ग रनिंग जमाबंदी का केस नहीं है। You have already been convicted in a criminal case and there is a finding against you.
should to be considered whether any order passed by the criminal case is binding upon
Yes, वो सब कहानी मत से आप जाइए अपना जाइए तक।
कुछ फैक्ट्स रख दिए जाए। इसमें
कुछ
दो
क्या
बार
fact चाहिए?
दो हमारे हैं, थोड़ा सा टाइम दिया जाए।
हाँ, टाइम आपको दे रहे हैं।
हाँ, थोड़ा सा टाइम दिया।
लॉ पॉइंट पे बहस।
हम लॉ पॉइंट पे थोड़ा सा
लिमिटेशन से बाहर है कि नहीं है?
कि हमारा रिवीजन ना
नहीं, आपका रिवीजन लिमिटेशन से बाहर
हाँ,
है।
बाहर है।
तो हम 226 में क्यों इंटरफेयर
हम
करेंगे?
करेंगे, हम बता देते हैं। थोड़ा सा हमको फैक्ट्स बता
अब
दीजिए।
कितना पार्ट था? टाइम
वो तो लिखा हुआ नहीं है।
लिखा हुआ।
वो तो लिखा हुआ।
आपको पता भी नहीं।
नहीं, हमको ही पता नहीं।
बहुत अच्छी बात।
हमको ही पता नहीं।
ना आपको पता है ना कोर्ट को
हाँ,
पता है।
कुछ फैक्ट बता देंगे, इससे पता चलेगा कि दिस कोर्ट विल इंटरफेयर।
नहीं सब चीज में
नहीं है, हमको तो एक बार टाइम दिया जाए, 2 मिनट भी कम से कम टाइम दिया जाए।
2 मिनट दिए। चलिए,
नहीं ऐसे
2
ही बोले।
minutes starts now.
लफ्ज़ द मार्क the lands of Khewat number 3/1
हमको फैक्ट नहीं बताने का
ये
जरूरत है।
फैक्ट
लॉ
जरूरी है, फैक्ट बहुत जरूरी है, तभी तो ये केस में हो पाए।
पिटीशन से दिखा, रिट पिटीशन।
हाँ, रिट
पढ़िए रिट
रिट
पिटीशन।
से पढ़ा जाता है। बेस्ट वाली पिटीशन। पहला 5 से पढ़ने मुझे।
पढ़िए।
The facts giving rise to writ petition is that land of RS Khewat number 3/1, 3/2 and 3/3 situated in village Dubla, PS Kamar, district Ranchi, are Mundari Kuch category tenancy in Khewat Dar of Khewat number 3/1, 3/2 and 3/3. Suklal Singh Munda, son of Sundar Singh Munda, Dhan Singh Munda, son of Gopal Singh Munda, Tirlal Singh Munda, son of Lakinder Das Munda. That the Khewat Dar of Khewat number 3/1, namely Suklal Singh died, leaving behind his only son Yadunath Singh. The said Yadunath Singh also died, leaving behind his only daughter Kumari Satya Bhama, who is the respondent number 6 in the present petition. ये भी देख कर दिए हैं, इनका सब्स्टिट्यूशन हुआ है, इनके हस्बैंड को पार्टी बनाए हुए। The Dhan Singh Munda, the Khewatdar of Khewat number 3/2 died issue. Similarly, Khewatdar of Khewat number 3/3, namely Tirlal Singh Munda also died, leaving behind his son only Suklal Singh Munda, the father of the petitioner. The Suklal Singh Munda, after the petitioner being the regnant and sole surviving male member, inherited the lands of above 3 Khewats and came in cultivating possession, being the only Mundari Kut category. The Suklal Singh Munda in exercise of exclusive right over the above favored board his name mutated in registered to in the office of Circle Officer Kamar, District Highway filed mutation case number 353 of 1962 and paid the rent and taxes with respect to land of favored number 3/1 to 3/3. 62 से ही हमारा जो है जमाबंदी चल रहा है. During the lifetime of Suklal Singh Munda several proceedings was initiated with respect to the lands of Khewas. In the year 1914, land was restored to him after disposing Mangal Lohar. In the year 1960, a proceeding under section 145 CRPC was initiated over the land of Khewas number 3/1 being case number so and so. In said proceeding, the possession of the Suklal Singh Munda was declared on 5/6/1963. That it is stated on the application, यहाँ से important हो रहा है, that on the application filed by the respondent number 6 in the year 1964, a proceeding under section 145 CRPC was initiated with respect to aforementioned land against the father of the petitioner, namely Suklal Singh Munda, being case number so and so. The aforementioned case was ended in terms of compromise between the party, and land measuring 15 acres 65 decimals was given to the respondent out of 391 acres and 52 decimals in lieu of maintenance. Mundari को खरीदारी में females cannot inherited that property lordship. That it is stated the respondent say being able to set compromise petition filed title suit number 18 of 1972 in the Munsif, which was dismissed by terms of the judgment dated 13/11/1973. In the title suit भी dismiss हो चुका है हमारे against. That amongst the Munda having to category pregnancy, females and person claiming to under her excluded from the inheritance, the females have no right of inheritance under customary law.
यहाँ डिसाइड करेंगे ये
नहीं डिसाइड हुआ है, हम आ रहे हैं थोड़ा सा.
कहाँ डिसाइड हुआ है?
इंक्वायरी हुआ एडिशनल कलेक्टर.
इंक्वायरी में डिसाइड होगा.
इंक्वायरी पर्सुएंट टू ऑर्डर पास बाय दिस ऑनरेबल कोर्ट लॉ.
कोई बात नहीं,
हमारे
इंक्वायरी में टाइटल सूट नहीं डिसाइड.
कोर्ट ने स्पेसिफिक
कोई बात नहीं, कोर्ट ने बोला इंक्वायरी में टाइटल सूट डिसाइड कर
टाइटल
दीजिए.
सूट नहीं वेदर द सुकलाल सिंह मुंडा इज द टेकलाल मुंडा और नो. There the specific direction of this honorable court earlier. I am coming out. The respondents file application before the circle officer. उसके बाद इनके नाम से रेंट कटा 74 में.
आपका कन्विक्शन हुआ है कि नहीं? खाली इतना
हमको क्या कन्विक्शन होगा?
ये जो लिखे हैं that he was, ये जो क्रिमिनल केस में आपका हुआ है कि नहीं?
नहीं हमको कन्विक्शन नहीं हुआ.
नहीं ये जो लिखे हैं
एम केस नंबर.
हाँ, आपराधिक मामले में वाद संख्या 267-69 दायर किया गया, जिसमें क्या नाम है, कौन राज के तेतला सिंह का पुत्र होने का दावा गलत पाया गया. यस,
दिखाएं तो रिकॉर्ड तो दिखाएं.
आप बताइए ना कि आप इसमें ऑर्डर में लिखा है, रिट पिटीशन में लिखे हैं कि ये गलत है.
नहीं हम तो
Is it there? नहीं
हम
लिखे है तो बात
लिखे.
खत्म है. फिर you this is not in dispute.
Then you say I will show the two order of the this honorable court.
हाँ बताइए कौन कौन सा
दो
order?
order.
This honorable court has repeatedly asked for this order.
अरे आपने बहुत परेशान, आप काहे इतना बहुत ज़्यादा परेशान?
Annexure 8 law से Annexure 8.
Annexure 8
हाँ
कौन फाइल किया था?
फाइल किए थे प्राइवेट रिस्पोंडेंट सत्यभामा.
जो यहाँ प्राइवेट रिस्पॉन्स.
हाँ वो फाइल किए थे.
ठीक.
In the writ application order continuing in Annexure 4 passed by the additional collector Ranchi Mutation Division number so and so. Also the order dated passed by the commissioner short from Lucknow are questioned. By the said order, the aforementioned authority held that the petitioner's name should not be mutated in respect of land in question. Allowed the appeal preferred by the respondent 6-11 against the order passed by the circle officer and deputy land reform as continuing in Annexure 2 and 3 to the writ application. Mr. So and so learned counsel appealing for the petition submitted the order of the circle officer based on the finding of the petition in favor of the petitioner in the proceeding under section 145 of the Code of Criminal Procedure. As would appear from the order dated 18/11/1970 as contained in Annexure 2 the writ application. If further drawn my attention to the fact there was a disputed question as to whether Suklal Singh Munda was in fact of the son of the Tirthal Singh Munda or no. From the period of Annexure 3, the writ application prepared the district and date on the basis of inquiry of the circle officer, as also application filed with the village in general that said Suklal Singh Munda was in fact son of Dubraj Singh of Kapadia village. This separate matter has not all been considered by the additional collector Ranchi. or Commissioner of Nagpur by passing the order as contained in Section 4 and 5 to the petition. Mr. So-and-so land council appearing for the respondent submitted that petition name could not be have been mutated in view of fact that she cannot be Mundari Kutvedari and increased under section 8 of the Sandapur TDC Act. Mr. Prasad further contended that both the respondent number 2 and 3 have based their decision on a number of the documents including the report of the Hadar Karamchari to the effect that name of the aforementioned Suklal Singh Munda is stood recorded in the demand register by order passed in 353 of 1962-63. Land council to the petitioner reply submitted this aspect of the matter, namely as to whether Suklal Singh Munda was son of Teslal Singh Munda or not has been considered any of the aforementioned order, and this requires a reconsideration. Further submitted, even assuming that petitioner could not become the Mundari Kutvedari in view of the provision of section 88 of the Kutnamu Financial Act, she is certainly a right to get her name mutated against the third person who is also not titled in the letter. From the procedure of the order passed by respondent number 2, 3 and 4, it appears that there are some controversy with regard to the fact as to whether the name of the Suklal Singh Munda was entered in the demand register with respect to Khevat number so-and-so, village, Dubla or not. Such controversy, in my opinion, cannot be decided in this court. I therefore direct the respondent number 2 to inquire in the matter after taking into consider the relevant reports and pass the police order. Thereafter, in event it is found that name of Suklal Singh Munda entered in the demand register after complying with all the formalities, no further inquiry may be necessary. And in that event, the question of filing of any application in terms of section 11 of CRK could not arise. As such, application for mutation filed must be held to be not. However, it is found that name of Suklal Singh Munda is not entered in the demand register by lawful order. He would consider the evidence in the record and give a finding as to whether the Suklal Singh Munda was in fact son of Dulal Singh Munda, village Kapadia, or thereafter he would pass a fresh order in accordance with the law. Thereafter, Lordship, may kindly see Annexure 9 Lordship. Order passed by the additional collector Lordship. Page 67.
Thereafter there was another round of litigation.
Yes, sir.
अब सीधे उसी में आ जाइए ना.
इसमें इस
रीट नंबर 2117 ऑफ 1995 आ. ये इंक्वायरी के बाद हुआ कि इंक्वायरी के पहले हुआ?
ये तो इंक्वायरी के बाद के ऑर्डर हुआ.
हाँ बताइए, इंक्वायरी के बाद कौन सा ऑर्डर?
इंक्वायरी के बाद का तो हाईकोर्ट में फिर दोबारा आ गई.
आगे दोबारा फिर
एनेक्चर 10 पढ़ते हैं लोग.
एनेक्चर 10
एनेक्चर 10
कहाँ पर? खाली फाइंडिंग पड़ी है ना, बाकी तो कहाँ नहीं.
पेज 73 और नीचे से पढ़ रहे हैं. बी
एक सेकंड, जस्ट अ मोमेंट. ये पेज नंबर 72 से पढ़िए.
72.
या फिर द फर्स्ट पार्ट ऑफ द डायरेक्शन.
The first part of direction could not be made available to the additional collector after remand, as the record were found traceless. As such, it could not be decided whether the name of Suklal Singh Munda, the predecessor of the respondent number 6 to 11, was recorded after publication on the preliminary. As regards the second point, as directed by the remand court, the learned court below held that predecessor of respondent number 6 to 11 be mutated to Khevat number 3 by 1, and that in the proceeding under section 140 CRPC permission declare in favor of the Suklal Singh Munda, the predecessor of respondent 6 to 11. Mr. Submission is that on the face of the record, learned petition collector in the order containing committed error of fact, it considered that the registration of name of Suklal Singh Munda in Khevat number 3 and particularly the Suklal Singh Munda as the grandfather of the petitioner, not the Suklal Singh Munda. The predecessor of respondent 6 to 11 by producing the judgment of the referral court under section 140 CRPC, it could not be shown that the punishment declared under section 145 CRPC is the step of that in view of the matter, it is submission of that and the additional collector has committed error of fact, thereby error of law relating the petitioner's prayer made under section 11 of the appearing court and on behalf of the respondent 6 to 11 submit that when there is an order made by petition collector on the basis of the demand order passed by this court, and there is no error of law in compliance with the order of this court, there is no scope of court to enter into the facts where there is a scope to the petitioner to move the before the civil court for declaration of the right title and interest. Annexure 7 should not be interfere with the system, but it could not be shown that the legislature has committed error of recording passing the order 17/1995 mutation revision number 7. The error recorded has caused the lieutenant additional collector arriving at a wrong decision. In view of the matter, this court can interfere with the order. Moreover, has referred the judgment of appeals court regarding the evidence of female Mundari as reported in.
अब यहाँ जाइए 73 का बॉटम.
73 का bottom. But what it may, I do not want to make any comment on disputed title of the party, but it appears the additional collector answer the head.
उसके बाद रिमांड कर दिया कि कुछ एरर ऑफ रिकॉर्ड है तो उसको रिमांड कर.
हाँ, रिमांड के बाद.
You see, the first court in the writ court also had observed that these disputes cannot be decided in writ application.
I am also.
The second court is also saying that disputed titles cannot be decided in writ.
Absolutely right.
Yes.
I am also not saying.
Go and get your title declared.
This is important. Thereafter I will note out in actual level. रिमांड के बाद जो ऑर्डर हुआ, इंक्वायरी हुआ, अपर समझता है.
ये जो इंक्वायरी है रिमांड के बाद मतलब फ्रेश इंक्वायरी, इसमें से क्या
इसमें बोला है कि सुखलाल सिंह मुंडा इज द सन ऑफ तेजलाल सिंह मुंडा एंड वेरियस डॉक्यूमेंट आर बीइंग शोन.
Now you tell me one thing. This particular inquiry, apart from the fact that it has been passed pursuant to direction of the court, is it referable to any provision of law?
But
this inquiry officer. Inquiry तो.
pursuant to order passed.
That's right. I want to know. I want to know this inquiry officer, right? Has got the right to decide inheritance. Has got the right to decide.
I am not saying inheritance.
Decide title.
No.
Then what?
No. But Lordship may kindly see, in lecture 11, Lordship, this is very much important for us, Lordship.
But
I am ready. This is the.
पूरा नहीं पढ़ना है, खाली relevant portion पढ़ना.
नहीं, छोटा सा.
छोटा सा नहीं है, 4 पन्ना इतना नहीं पढ़ सकते हैं.
इसको पढ़ना, यही तो कुछ बार नहीं पढ़ेंगे कुछ ना, उसके बाद में कुछ नहीं पढ़ेंगे. देखो उपयुक्त विषय में वाद संख्या उपयुक्त विषय वाद में दिनांक 3/6/2006 पारित आदेश अनुपालित इस मामले में जांच की गई. जांच के लिए दोनों पक्षों को विधिवत सूचना दी गई. सूचना को उपरांत दोनों पक्षों ने अपना समर्पित करने का अवसर प्रदान किया. आवेदक की तरफ से अपने दावे के पक्ष में कागजात समर्पित किया, लेकिन सूचना के बावजूद प्रतिवादी की तरफ से कोई कागजात एवं सबूत प्रस्तुत नहीं किया गया. ये एलिगेशन लगा रहे कि हम दुबलाल के बेटे हैं. इस मामले में अंचल अधिकारी तमाम को सूचना देकर प्रतिबंध प्राप्त की गई. जैसे कि आदेश संख्या दिनांक 30/6/2002 में अंकित है. आवेदक का दावा खेवड़दार तेजलाल सिंह मुंडा के पुत्र है, जिनका विपरीत प्रतिवादी का दावा तेजलाल सिंह मुंडा निसंतान मर गए हैं. वर्तमान में आवेदक वास्तव में मौजा कपाड़िया में दुबराज सिंह के मुंडा का पुत्र है. जांच का मुख्य बिंदु ये आवेदक सुखलाल सिंह मुंडा वास्तव में तेजलाल सिंह मुंडा का पुत्र है अथवा दुबराज सिंह मुंडा का पुत्र. इस बात में जांच मेरे द्वारा की गई जांच प्रतिबंध निम्नवत है. प्रतिवादी के पक्ष में कोई सा सबूत या कागजात नहीं दिया गया जिससे प्रमाणित हो सके कि आवेदक सुखलाल सिंह मुंडा कपाड़िया दुबराज सिंह मुंडा का पुत्र है. इन्हें अवसर देने के बाद भी अपने तरफ से कोई कागजात एवं सबूत समर्पित नहीं किया. स्पष्टतः प्रतिवादी अपने दावे के बिंदु प्रमाणित करने में असमर्थ रहे हैं. आवेदक पक्ष द्वारा यह बताया गया कि सुखलाल सिंह मुंडा की मृत्यु होगी, उनकी पत्नी जीवित है. आवेदक पक्ष कपाड़िया गांव के निवासी नहीं बल्कि दुबला गांव के निवासी. आवेदक पक्ष के द्वारा अपने दावों में समर्पित कागजात प्रस्तुत किए. वर्ष 1975 में 301 कमांड निर्वाचन क्षेत्र के निर्वाचन सूची भाग संख्या 3 ग्राम दुबला के प्रति इसमें मतदाता सूची क्रमांक 3 में सुखलाल सिंह मुंडा पिता तेजलाल सिंह मुंडा, क्रमांक 4 पर सुभद्रा देवी पिता पति सुखलाल सिंह मुंडा दर्ज है. कमांड विधानसभा के निर्वाचन सूची वर्ष 1975 भाग संख्या 156 मौजा दुबला जिसका क्रमांक 156 पर सुभद्रा देवी पति सुखलाल सिंह मुंडा, बद्रीनाथ मुंडा, सुखलाल सिंह मुंडा, द्वारिका सिंह मुंडा पिता सुखलाल सिंह मुंडा अंकित है. सर्वे तनाजा संख्या 1 दिनांक 5/9/77 फेरिक ऑयल सत्यभामा देवी पिता जोगनाथ मुंडा, फरीक गोविंद सुखलाल सिंह मुंडा पिता तेजलाल सिंह मुंडा, दिनांक 10/9/1977 पारित आदेश का अभिमानी प्रति. इस वाद में सत्यभामा देवी द्वारा सुखलाल सिंह मुंडा के विरुद्ध तनाजा दायर किया. ये प्राइवेट रिस्पॉन्स फाइल किए.
इसमें से कौन सा डॉक्यूमेंट ऐसा है जो 145 प्रोसीडिंग का से पहले का वन डॉक्यूमेंट 145 का जो प्रोसीडिंग हुआ था ना पहले, राइट, उसके पहले का कौन सा डॉक्यूमेंट? विधानसभा का it's a document of title, document of inheritance.
I am not saying the voter list is a document of title.
तो
और आगे पढ़ देते हैं.
You see 145 प्रोसीडिंग हुआ था 61 में. उसके पहले का कौन सा डॉक्यूमेंट?
उससे पहले देख और थोड़ा सा
यही तो है सारा डॉक्यूमेंट्स जो आप प्रोड्यूस किए, सब बात का है।
और नीचे भी है
और नीचे कौन सा है, एक ही दिखाइए ना।
नहीं ई पढ़ा जाएगा उससे ई के जब दो लाइन खाली पढ़ रहे हैं नीचे में सतभामा मुंडाई ने मुकदमा किया है। इस मुकदमे में प्रतिवादी के रूप में सुखलाल सिंह मुंडा पिता देवलाल सिंह मुंडा मौजा दुबला अंकित किया गया। केस हमारे पर किया था, उसमें खुद ही लिखे हैं कि सुखलाल सिंह मुंडा इस दस्तान और देवलाल सिंह मुंडा अंकित है, जो कि प्रमाणित करता है सुखलाल मुंडा पिता देवलाल सिंह मुंडा के थे और दुबला के निवासी। दफा 83 के अंतर्गत मुकदमा संख्या 264 दिनांक 3/7/1998 में सुखलाल सिंह मुंडा पिता 23 मुंडा साकिब दुबला का नाम दुबला नोटिस मुकदमा संख्या 264 के आवेदन के प्रति मुकदमा संख्या 246 धारा 83 के अंतर्गत सत्यभामा मुंडा द्वारा आपत्ति आवेदन के प्रति इस मामले में निरस्त नोटिस को प्रति
सत्यभामा मुंडा वो जो है वो प्राइवेट रिस्पोंडेंट डिस्क्रिप्शन में इन द पार्टी पोजीशन, अगर मान लीजिए यहाँ पे कोई केस फाइल हो जाए और रिस्पोंडेंट का नाम में जो डिस्क्रिप्शन हो कुछ और डिस्क्रिप्शन दे दीजिए, केस चलेगा? नहीं चलेगा, नहीं चलेगा ना। तो लॉ पॉइंट का बात नहीं, ये एफिडेविट में पार्टी पोजीशन में ये सब चीज
वोटर लिस्ट में भी नाम आना
वोटर लिस्ट में नाम बाद में है। यही एक चीज हम आपको बोल रहे हैं, लड़ाई ना 1960 से चल रहा है, वोटर लिस्ट में नाम बाद में है जी। इसका क्या रेलेवेंस?
माय सजेशन इज अकॉर्डिंग टू कस्टमरी
अब आप मेरा सबमिशन सुनिए, यहाँ एक लाइन बोलिए।
हाँ, अकॉर्डिंग टू मुंडारी कस्टमरी लॉ whether female can inherit the property or not.
हम तो नहीं जानते।
They cannot be inherited.
I do not know. ऐसा तो कोई मतलब यहाँ पे कस्टमरी लॉ ना मेरे पास एविडेंस है ना हम जानते हैं।
नहीं, कस्टमरी लॉ में कि मुंडारी पुत्रधारी में फीमेल इनहेरिट
आप जानते हैं, आप विद्वान हैं, हम नहीं है विद्वान आपकी तरह।
उर्दू सीख रहे हैं
अपना
यही हमारा सजेशन।
आपको क्या बोलना?
No, it has been categorically stated that he has been declared to be an imposter. That is the case number, it is already there. High Court ने 2 बार इनको इन्फॉर्मेशन दिया है, ऑर्डर शीट में भी रिफ्लेक्टेड है कि आपको ऑर्डर शीट फाइल कीजिए। At the same time, my lords, I will say that इनका क्या मेंटेनेबिलिटी है इस पिटीशन का? If he has already been declared as an imposter, what status he has to file a case over him?
और आपको कुछ बोलना है? It requires adjudication by civil, इतना ही तो, and it should be decided without prejudice to any observations made, correct? है ना?
हम अपने कंसेंट नहीं दे रहे हैं।
कंसेंट की अगर आपको वो लाइन नहीं चाहिए तो हम नहीं लिखेंगे।
नहीं, आप लिखा दीजिए अपने तरफ से, मेरे तरफ से नहीं।
तो
आपको नहीं चाहिए, अपनी तरफ से हम लिखा देंगे।
क्योंकि डिसाइड तो एक बार प्रथम श्रेणी दंडाधिकारी के इधर से हुआ है, हमारा तो
क्रिमिनल मैटर है, क्रिमिनल मैटर।
WPC number 5528 of 2006. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the case has a checkered history and there has been multiple rounds of writ petition also in the present case. The core of the dispute is whether
इससे पहले भी लॉर्डशिप उसको सुन चुके हैं, पुराना है।
हमको थोड़ी याद
नहीं सुने थे।
उस समय भी सीनियर बचा लिए थे, आज कोशिश कर रहे थे।
is whether Sukhlal Singh Munda was son of
तेतलाल सिंह
Munda or not. The learned counsel submits that the details of the genealogy has been mentioned in the writ petition right from paragraph 5 onwards. and Sukhlal Singh Yadav claiming inheritance got his name mutated in Register 2 in mutation case number 353 of 1962. However, a proceeding was initiated in the year 1960, numbered as under section 145 CRPC, numbered as case number M67 of 1961. And the possession was also declared in favor of Sukhlal Singh Munda on 5/6/1963. Thereafter, another proceeding was initiated in the year 1964 under section 145 CRPC, which was numbered as M case number 176 of 1964, which ended in a compromise. And pursuant to the compromise, land measuring 15 acres 65 decimal was given to respondent number 6 out of 391 acres and 52 decimal. However, the respondent number 3 filed a title suit number 18 of 72, which was dismissed in terms of order dated 13/11/1973. He submits that as per tribes of Munda, the female do not have right to inherit property, they are only entitled to maintenance. However, the respondent number 6, in spite of their foresight, the respondent number 6 filed an application before the circle officer for mutation, which was numbered as mutation case number 31R15 of 1974-75, which was allowed in her favor and affirmed by the appellate authority in appeal number 21 of 73-74, against which the father of the petitioners filed revision number 31R15 of 74-75 before the additional collector, which was allowed by order dated 1/7/1975. A revision was preferred by the respondent number 6, which was dismissed by order dated 23/2/1981 in revision number 422 of 1978. The respondent number 6 filed a writ application before this court, being CWJC number 1442 of 1981, and the matter was remanded. And thereafter, certain orders was passed, which led to filing of another writ petition by respondent number 6, which was numbered as CWJC number 2117 of 1995 (R), and the matter was again remanded by order dated 7/10/1996 before the additional collector. He submits that thereafter, pursuant to the order of remand, the necessary inquiry was made, and it was found that Sukhlal Singh Munda was the son of late Tetlal Singh Munda, and he was resident of village Dukla. The learned counsel submits that The Learned Counsel has referred to the Learned Counsel submits that the Deputy Commissioner, without properly considering the materials on record, ultimately dismissed the revision in terms of order dated 18/12/2005. Against which mutation revision number 11 of 2006 was filed before the Court of Commissioner, who also arbitrarily dismissed the revision primarily on the point of limitation. The Learned Counsel has referred to the revisional order and has submitted that once an inquiry was made that Suklal Singh Munda was the son of
Tetlal Singh.
Tetlal Singh
Tetlal Singh
Munda of village yes of village be important.
Dubla, village Dubla.
Dubla.
Ada. 21 million.
Yes. Any order passed by criminal court wherein the claim that the petitioner was Suklal Singh Munda was not rejecting the claim that Suklal Singh Munda was the son of Tetlal Singh Munda has no bearing in this case, and has submitted that the impugned order of the Commissioner is fit to be satisfied. The Learned Counsel, appearing on behalf of the private respondent, has submitted that it is not in dispute that in the criminal case bearing number 287 of 69,
267.
60?
67.
66.
267.
267 of 1969. It was found that Suklal Singh Munda was not the son of Tetlal Singh Munda. Tetlal Singh, na? The Learned Counsel submits that once there is a finding of a competent court that Suklal Singh Munda was an impostor, under such circumstances, the revision has been rightly dismissed, apart from the fact that it was barred by limitation.
After this decision, this respondent has been paying rent and receiving rent. That is also there. इसके बाद ही सब.
The Learned Counsel, representing the private respondent, has submitted that the private respondent has been paying rent to the state. He has also submitted that the Commissioner has rightly observed that the matter relating to title cannot be decided by revenue authorities. To this, the learned counsel for the petitioner has submitted that the inquiry was conducted pursuant to the order of the court and finding which was conducted by
Additional collector.
the additional collector, who is certainly a revenue authority, but the finding of the additional collector is binding, and therefore
And it was found that
But-
Suklal Singh Munda
wherein it was found that Suklal Singh Munda was the son of Tetlal Singh Munda. He submits that conviction in the criminal case has no bearing. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that in the first round of litigation in writ petition being CWJC number 1442 of 1981,
इससे पहले कंप्रोमाइज हुआ तो उसमें टाइटल
कोई बात
टाइटल में
नहीं,
दिया
बस कोई बात नहीं. The court, after considering the arguments of the respective parties, observed that from the perusal of the order passed by the revenue authorities, it appeared that there was some controversy with regard to the fact as to whether the name of Suklal Singh Munda was entered in the demand register with respect to Kevat number 3/1, 3/2 and 3/3 of village Dubla or not. And the court was of the view that such a controversy cannot be decided by the writ court, and the respondent number 3 of the said case was directed to inquire into the matter and take into consideration relevant records and pass a fresh order. The court also observed that if it is found that the name of Suklal Singh Munda was entered in the demand register after complying with all formalities, no further inquiry may be necessary. It was also observed that if the name of Suklal Singh Munda is not entered in the demand register by a lawful order, he would consider the evidences on record and give a finding as to whether Suklal Singh Munda was in fact son of Dubraj Singh Munda of village Kapadia or not. And a fresh order was required to be passed. ये विलेज कपाडिया का तो आपका फाइंडिंग नहीं है इंक्वायरी ऑफिसर का? देखिए किसका कौन सा विलेज दिया है?
जितने सभी कागजातों को पेज 77 में सभी कागजातों को सम्यक रूप से विवेचन के उपरांत मैं पाता हूँ कि स्वर्गीय सुखलाल सिंह मुंडा पिता स्वर्गीय तेतलाल सिंह मुंडा थे और वे ग्राम दुबला के निवासी थे।
दुबला, लेकिन इसमें तो कपाड़िया लिखा हुआ है।
इसमें तो आया हुआ दुबला,
लेकिन ऑर्डर में कपाड़िया लिखा हुआ है।
उनके ऑर्डर में
ये हाईकोर्ट के ऑर्डर में।
और यहाँ तो लिखा हुआ दुबला,
दूसरा विलेज हो गया ना?
वो
दूसरा विलेज है ना?
दूसरा विलेज है।
However, thereafter certain orders were passed and the private respondent again approached this court in CWJC number 2117 of 1995. against the order passed, order dated 1/7/1995, fresh order dated 1/7/1995, passed by the Additional Collector Ranchi in Mutation Revision Case number 10R15 of 8788. The learned court referred to the earlier order passed in CWJC number 1442 of 1985 and quoted the same, quoted the operative portion, and thereafter the court observed that the first part of the direction could not be made available to the additional collector after remand, as the records were found traceless, and it could not be decided whether Suklal Singh Munda, the predecessor in interest, the predecessor of respond number 6 to 11 was recorded after application of all formalities. With regard to the second point, the court observed, the court thereafter recorded the submissions of the respective parties and observed that the court did not want to make any comment on disputed title of the parties. But the learned additional collector arrived at his findings on mistake of fact and on error of records. And therefore, the order was set aside. And the additional collector was directed to pass fresh order after giving opportunity of hearing to the parties as per the direction given in the earlier repetition, being CWJC number 1442 of 1981 within bracket R. Thereafter, as per the inquiry report, which was and as contained in Annexure 11, it was primarily based on the certain documents, including the electoral roll of the year 1975 and certain proceedings of the year 1977. It was also recorded that one FIR was also instituted. And was also referring to certain petitions where the private respond number 6 had shown Suklal Singh Munda as son of Tetlal Singh Munda. And ultimately, the additional collector, on the basis of documents, held that Suklal Singh Munda, the father of Suklal Singh Munda was Tetlal Singh Munda, and they were resident of village Dubla. And no documentary evidence was produced from the side of the private respondent 6. Thereafter, fresh order was passed. Fresh order उसके बाद कौन सा है? By the Deputy Commissioner at Annexure 15, wherein the Deputy Commissioner Ranchi passed an order rejecting the claim of the petitioner and has also referred to the judgment passed by criminal court that the claim of the Suklal Singh Munda being son of Tetlal Singh Munda was found to be not correct. And the court also and the authority also recorded that at present the private respondent is in possession of the property, and ultimately directed that the Jamabandi be opened in the name of the private respondent number 6. This order was passed on
18/4/2005.
18/12/2005.
18/4.
18/4/2005. Thereafter, the matter was taken up before the revisional authority, who passed an order under dated 6/8/2006, and has also referred to the criminal case and did not interfere with the order passed by the commissioner, and also observed that the revenue authorities have no jurisdiction to decide the matter of title. The revisional authority decided the case not only on merits but also observed that the revision was barred by limitation, and the revision and no explanation and no cogent explanation was furnished for the delay. This court is of the considered view that the orders passed in the previous writ petition also revealed that the court had observed that such disputed title of the parties cannot be decided in writ jurisdiction. However, certain inquiry was directed to be made, which was conducted by revenue officer. The fact remains that there is a pronouncement of a criminal court that Sukhram Singh Munda was not the son of Tetlal Singh Munda. However, the judgment of the criminal court has not been placed on record, and this aspect of the matter is also not in dispute in the writ petition. No, in the writ petition, in the writ petition. This court is, and admittedly the private respondent number 6 was found to be in possession of the property. This court is of the view that the order passed by the Deputy Commissioner for opening Jamabandi in the name of the private respondent number 6, primarily on the basis of possession, and rejecting the claim of the petitioner was a well-reasoned order, taking into consideration the entire matter placed before the authority, and the learned commissioner has rightly refused to interfere with the order passed by the commissioner by the impugned judgment, by the impugned order. The commissioner has already observed that the matter relating to title cannot be decided by revenue authorities. In such circumstances, this court finds no reason to interfere with the impugned orders under Article 226 of the Constitution of India. Accordingly, this writ petition is hereby dismissed.
सूट के लिए।
At this, the learned counsel for the
अपने
petitioner,
तरफ से
हम अपने तरफ से नहीं देंगे,
उसमें बाइंडिंग हो जाता है, हाई कोर्ट का ऑब्जर्वेशन होता
हम
है।
कुछ नहीं देंगे, मांगिएगा तो देंगे, आप बोले बिना मांगे हमको दे दीजिए, नहीं देंगे, इतना जेनरस हम नहीं। शुरू में बोलते तो 1 मिनट में दे देते, अब नहीं देंगे। आप आपका सबमिशन लिखा के देंगे, सबमिट करिएगा तो देंगे, नहीं सबमिट करिएगा तो नहीं।
हमारा सबमिशन मिले।
At this, the learned counsel for the petitioner has submitted that this order may not prejudice the case of the petitioner if appropriate remedy through process of court before the civil court is undertaken by the petitioner.
डिस्पोज ऑफ नहीं करेंगे।
कैसे dispose of कर देंगे?
डिसमिस नहीं, डिस्पोज ऑफ करेंगे।
It is, however, it is made clear that this order will not prejudice the either parties if appropriate remedy seeking declaration of right, title, interest, possession,
वो रिकवरी
and the status of the concerned person is taken through a competent court of civil jurisdiction.
वो रिकवरी
सारा सब तो हो गया। पोजेशन मतलब रिकवरी भी।
सूट तो ऐसे भी बात नहीं होता है।
नहीं, अब यहाँ आ गया तो अदरवाइज लिमिटेशन है ये, तो आ गया हमारे लिए
पॉइंट ऑफ लिमिटेशन कैसे कंट्रोल हो सकता है?
हम कुछ नहीं, हम तो
वही तो।
उसके बारे में कुछ नहीं बोल सकते।
तो मैं
जहाँ अथॉरिटी का ऑर्डर था वहाँ आप राइट टाइटल मांगिए।
कहाँ मांगे
चलिए पकड़ो।
Under heading for orders, item 2, WPC 1730/2006.
ये नहीं की
क्या है ये?
प्रीएम्पशन का दोनों कोर्ट से हम जीते हैं। एक जगह
कौन है आप? परचेजर है?
परचेजर है और 2 जगह सब जीते हैं। डीसीआर की उन्होंने फाइल किया, प्राइवेट रिस्पोंड को डिसमिस
आज जीतने का मन नहीं है।
कर दिए ले तो
क्या मैटर बताइए ना, कुछ तो बताइए। को शेयरर है कि कौन है आप?
नहीं, हाँ परचेजर
परचेजर है। को शेयरर कौन है?
को शेयर कोई नहीं है।
प्रीएम्प्टर कौन है?
प्रीएम्प्टर है प्राइवेट रिस्पोंड।
प्रीएम्प्टर who is the preemptor? एडजॉइनिंग रैयत है कि को शेयरर?
नहीं, क्लेम कर रहे हैं कि हम को शेयर है।
अच्छा,
क्लेम कर रहे हैं को शेयर है, ऐसे को शेयर नहीं है। दोनों कोर्ट में हम जीते हैं और लॉर्डशिप बोर्ड ऑफ रिव्यू का ऑर्डर देख लिया जाए।
एडजॉइनिंग नहीं है।
नहीं, हम तो परचेजर है।
जो प्रीएम्प्टर है वो एडजॉइनिंग भी तो होंगे ना।
ये थोड़ा सा वेरीफाई कर लो। बहुत सब फैक्ट्स दो के एक साथ हो जाने से मिक्स अप हो जाता है। रोज का ऐसे ही होता है हमारे साथ।
आप ऐसा क्यों बोल रहे हैं? केस हारते जीतते थोड़ी है।
नहीं, हार नहीं रहे हैं।
लिटिगेंट हारता है।
नहीं, फैक्ट जो है
आप बताइए,
mix
आपको
up।
बिना सुने कोई ऑर्डर कर दिया हो?
नहीं, कभी नहीं, वो गिरवान तो नहीं है। पर क्या होता है कि 2-3 केसों में फैक्ट्स मिक्स अप हो जाते हैं। वो
कोई बात। ठीक है, बताइए कब करेंगे?
सोमवार को
एक सेकंड।
हम खाली ऑर्डर पढ़ते रहे हैं इनका बोला प्लेटू का। पेज 49 नोट 6।
वहीं पर
However, both the courts below have added holding that respondent number 1 to 3 are co-sharer of the section so and so. Clearly stipulated that he has to be established that the vendor is not the co-sharer of the vendor. In the instant case, in Chester of the respondent number 1 to 3 may have been the Katyani area, but there have been number of the transactions through the legally varied sale deeds of the disputed property. The first transaction was whenever Narayan Chaudhary, the grandson of recorded in 45 decimal to the Moni Devi, Dolati Devi, Jaswa Devi and Dulia Devi. Moni Devi and Dolati Devi then sold the share 24 decimal to Reva Mato, and Reva Mato subsequently sold 24 decimal land to the petitioner. Dulia sold the 12 decimal apparent to respondent number 1 to 3, while the Jaswa Devi subsequently sold her share to 12 decimal to the petitioner. Respondent number 1 to 3 may be the co-sharer of the Narayan Chaudhary, but Narayan Chaudhary forfeited all claims right over the disputed land.
क्या बचा है?
नहीं, इसको सुमार की
नहीं, वो तो आप देख ही रहे हैं।
हम सुमार
आप बताइए इसमें कुछ है करने लायक तो?
नहीं है, इसीलिए बोलते हैं सुमार को हम कर रहे हैं।
सुनिए।
1 दिन के लिए करिए हम मान रहे हैं।
एक दिन कल
निकल हम बाहर जा रहे हैं इसीलिए, अदरवाइज कल ही हम कर लेते हैं। अब
मतलब एक केस बहस करके बाहर चले जाते
नहीं, कल हम जा रहे हैं एक रिलेशन में ग्रीन पर से जमशेदपुर में से
ठीक।
अदरवाइज हम तो एब्सेंट भी नहीं करते हैं।
ठीक। WPC नंबर 1730 of 2006। प्राइवेट रिस्पोंडेंट कौन है? ओके। The counsel for the petitioner is present. Petitioner and the state is present. Nobody appears on behalf of private respondent. However, the petitioner has commenced hearing and has placed the impugned order. The petitioner claims to be the purchaser of the property.
No.
He submits that the learned member board of revenue has wrongly held that the petitioner is not the co-sharer of the property. Okay?
So, Mark,
Close this case on Monday? Monday नहीं. Monday कुछ रखे हैं क्या? मैं 2:15 बजे.
सावन तो कोई केस है नहीं नहीं
2:15
yes.
on Monday at 2:15.
Yes.
लेकिन कुछ हो सकता है, कुछ अलग तरह का असाइनमेंट आने का चांस है.
ठीक, कोई नहीं, हम
तो अगर वो अर्जेंट मैटर्स होंगे तो उसको करने के बाद करें.
जी
ठीक है?
जी would like.
Since the counsel for the private respondent is absent, let a soft copy of this order be forwarded to the counsel to ensure his appearance.
Item 3 WPC 3368 of 2006.
Petitioner,
Your Lordship, it has been informed that some of the respondents are no more in last hearing. However, we have not been provided with the particulars of their legal hire.
so
No,
who will provide? Who will provide?
Your Lordship, from respondent, we have seen.
They are the relatives. The appearing respondents are the relatives. Whom are you representing, Mr. Mishra? Whom are you representing?
I am representing on behalf of respondent number 1A and B. Respondent number 1 and C. 1C died 24 years ago. 2-3 died 12-13 years ago. And the petitioner has taken time on 29/8/2024 to file substitution since the sum of the respondent died.
कहाँ से मिलेगा कौन कब मरा है? From where will I get this? कोई ऑर्डर में रिकॉर्डेड है?
हाँ, ऑर्डर में recorded है कि I have also submitted for this court that they have died. This is a case of 2006. Notices we have appeared on 5/1/2010.
किस ऑर्डर से हमको मिलेगा कौन मर गया?
एक कृष्णा हेमब्रम जो हमारा इंस्पेक्शन है उसके
कौन 3, 4 and 5?
हाँ,
They all have died.
2 and 3 died and 1C also, 1C Krishna Hembram also died.
नहीं, report says that notice could not be served due to 3, 4 and 5. तीनों का डेथ हो गया. 3, 4, 5. As per the office note.
और तो इसमें है
नहीं है.
नहीं, पिटीशन में तो नहीं, इसमें पार्टी है,
पिटीशन में 4 नहीं है.
रेस्पॉन्डेंट नंबर 1, 2 and 3 ही लिखा।
नहीं 5 रिस्पोंडेंट है, कैसे बोल रहे हैं?
हमको जो मिला है नोटिस में
नहीं,
It is
3, 4 and
all
5.
sorts of dates, Som Hemrom and
नहीं,
Hemrom.
3, 4 and 5 have expired. One is only son of late Soman Hemrom. The other is son of late Barka Hemrom. Yes. And you see, you are resident of the same village.
यस
So, you are resident of the same village. क्या बोलते हैं आप?
मंगल हेम्ब्रम तो 17 साल पहले बताया कि मार गया और जो जुनू हेम्ब्रम 12 साल पहले
सेम विलेज के हैं भाई, दूसरा जगह से थोड़ी आए हैं, चांद में नहीं रह रहे आप, पड़ोस में है, आपके पड़ोस में आदमी मर गया। इसका जरा और दिखाइए सर्विस रिपोर्ट और
Lordship, names and addresses of legal representative can be provided to us.
चलो अब कुछ नहीं हो सकता. आप कौन है?
Respond number one का A और B.
And what is the matter?
Matter related to settlement operation is going on. The settlement officer and the government commissioner have passed the order in favor of this.
One order, only one settlement, or there are different settlements?
This is current service.
ये जितने भी respondents हैं,
हाँ.
they are concerned with one settlement, or they are concerned with different settlements?
Present current service settlement in operation in Santapur.
हम आपसे ये पूछ रहे हैं कि कौन भाषा में समझे. ये सेम एक ही सेटलमेंट से रिलेटेड है कि सब रेस्पोंडेंट का अलग अलग सेटलमेंट है?
नहीं, एक ही सब एक ही.
बताइए कौन है आपके सीनियर? कौन वाले राजीव
एडवोकेट जनरल.
इस केस में उन्हीं को करना है क्या?
नहीं, सीनियर ही आने वाले हैं, लेकिन उनका केस
वो इस केस में नहीं आएंगे. कौन है आपके सीनियर?
पीयूष सर.
एडवोकेट जनरल इस केस को नहीं कर सकते.
हाँ.
क्या करें? आपका तो प्रोसीडिंग अबेट कर गया.
पार्टी
Proceeding is abated, and you are the resident of the same village. क्या कंफर्म करेंगे? एड्रेस में तो लिखा ही हुआ है, आपका पड़ोसी है. Yes. WPC number 3368 of 2006. As per the report received way back on 18th December 2021, the respondent number 3 Krishna Hembram, respondent number 4 Chunu Hembram, and respondent number 5 Mangal Hembram have expired. The service report also indicates that the information regarding death of Krishna Hembram was provided by his cousin brothers Hopna Hembram and Sanatan Hembram, and the information regarding death of Chunu Hembram was provided by none less than his son, namely Sanatan Hembram, and information regarding respondent number 5, death of respondent number 5 Mangal Hembram, was provided by his sons, namely Munesal Hembram and Hopna Hembram. Further, it is not in. Further, from the cause title, it appears that the address of the petitioners and the respondents are one and the same. In spite of the aforesaid, no petition seeking substitution has been filed. Admittedly, the proceeding has abated as against the respondent number 3, 4 and 5. और कौन मर गया सर? Post on next Thursday at 2:15. The petitioner to address as to whether any relief can at all be granted to the petitioner. कोई बहाना नहीं चलेगा, हम एकदम मतलब हम बता दे रहे हैं, आपका सब्स्टिट्यूशन भी उठा कर देते हैं. सर्विस रिपोर्ट में बेटा का नाम दिया हुआ है, कहाँ खोज रहे हैं आप? Where are you looking for? Yes? आपको परोस के देंगे हम लोग. बेटा बता रहे हैं, नाम दिया हुआ है. No further adjournment will be granted. Adjournment का cost होगा 1 लाख. If you pray for it. ठीक है? चाहिए. बुला दीजिएगा अपने सीनियर को बहस करने.
Item 4 WPC 7737 of 2006.
Petitioner
last day petitioner has to file IA, substituting the sole petitioner and the respondent number 5. Order dated 8.
No such steps have been taken. Have they filed anything?
Subsequent petitioner. They haven't filed.
देखिए WPC number 7737 of 2006. It has been recorded in order dated 8/1/2025 that the sole petitioner and the respondent number 5A has expired, and time was, and upon prayer 3 weeks time was granted to file interlocutory application for substitution of the sole petitioner as well as respondent number 5A. Today, nobody is appearing on behalf of the petitioner. Neither anybody is appearing on behalf of the petitioner nor any petition for substitution is been filed. Accordingly, this proceeding has abated. Next.
Under heading for admission, item 5, WPC 5253 of 2006.
Petitioner? Yes. Sorry? I can't hear you. Louder.
The standard petition has been filed against the order dated 28/3/2006 passed by the petitioner in draft organization, wherein he has affirmed the order dated 19/6/1985 passed by ASO in MA case number 114 of 1985. The brief fact, my lord, is that the interim order is that my lord, page number 23. I'm just recapitulating the brief fact, my lord. There is one disputed premises, my lord, that has been recorded in the name of the petitioner, ancestors of the petitioner and respondent second set. Subsequently, the respondent second set were evicted, ancestors of respondent second set were evicted on the ground that they have made an illegal variation to one Soku Pandit. And on that account, they have been effectively evicted in the year 1989. Thereafter, the title suit was filed by Makhan Lai, who was the ancestors of respondent first, the second party, and the respondent second party. Pursuant thereto, a decree was passed in the said title suit, and based on that decree, the respondent second set have came into the possession.
That it was decreed in their favor.
It was a compromise. It was a compromise.
Compromise. With whom?
With the respondent first party who were given the possession due to the eviction earlier application in the year 19.
The possession was granted by whom?
Possession.
By way of settlement.
Yes.
So that settlement was set aside through a compromise.
Through a compromise in the title. Thereafter, in the recent further settlement.
When was the decree passed?
Decree was in the year 1940, my lord, in
1940.
40.
Okay.
1940. In the subsequently, my lord, in the recent service settlement, before the learned ASO, my lord, he has affirmed the possession in favor of respondent second set and has passed an order for eviction of respondent first party. Respondent thereafter, respondent first party preferred appeal before learned ASO, which wherein the order of learned ASO was set aside and same order has been performed.
The first order is in your favor,
First,
and remaining two orders are against you.
and it has been set aside.
You are whom are you representing?
Private respondent.
Private respondent.
One more thing, it has been set aside on the ground that the compromise decree was a collusive decree. Now, if the collusive decree, whether the main issue here is whether a decree which has been obtained by fraud, whether it can be set aside in a settlement proceeding.
You see, it is a fraud on statute. These lands are absolutely non-transferable. It's a nullity. इसको set aside करने का जरूरत ही नहीं है. It can just be ignored.
Finding, ये finding पे arrive कर सकते हैं whether he has whether the learned ASO has exceeded his not ASO has exceeded his.
See, these lands are non-transferable as per the statute. The settlement was made by the deputy commissioner, must be or SDO, in favor of first party. है ना? उनको नहीं चाहिए था तो सरेंडर करना चाहिए था जमीन, वो दूसरे को सेटल कर देते. You see, these are not arising out of SPT Act. These are the general transfers. There is no doubt that a compromise decree can be set aside by a competent court. In the general principles, there is no problem about it. But there is a bar under the statute. Through compromise, this amounts to transfer, and the transfer is.
That is true. That is true. Whether the SO has exceeded its limit, may read the relevant part of the SO.
Impugn order.
Impugn order, learned SO was set aside.
Annexure 3.
Annexure 2. Page number 19. Start from page number 19.
Okay.
And starting from last, I have heard.
Yes.
I have heard the learned act laws for the parties and examined the records of the case and document produced by the party. I have also gone through the order of the ASO dated 12/12/2006.
It appears that he has only challenged the commissioner's order.
It doesn't make any difference. It all merges. आगे बढ़िए.
In the eviction alienation case 681 of 1938-39, by order dated 7/3/39, the SDO has recommended for eviction of both aliener and alienee. The DC by order dated 10/4/39 order eviction. Subsequently, on 21/8/39, the land was settled with one Tanzim Naik. However, on 5/1/39, the SDO records that Tanzim Naik is not deserving as he is big Jamia, and therefore previous settlement is cancelled, and the land, that is plot number 1861, area 6 Bigha, 14 Katta 16 are settled with very poor relatives, namely Mangur Mani. These are the Mangur Mani, the ancestor of respondent first party, and his brother Duna Maji on 5/2/40. The SDO records in his order sheet that there is no need to revise the settlement with Mangur Maji and Duna on 5/2/41. It is recorded that A study is given. It is admitted that Mangu Manji and Yuna Manji are ancestors of the appellants. Entitled suit 8 of 1940. Now this is the suit to which the respondent second parties have come.
Just a moment. It is recorded that Basgari is given. It is admitted that no need to revise the settlement. Who is this Mangur Manji and Dunya? They are the previous settling.
They are the ancestors of Mangu.
You see, the settlement was made with one Tajim like.
This settlement was cancelled.
Okay, you are not concerned with that. Okay.
Entitled suit number 8 of 1940 in the court of rule of Deputy Collector at Dumka, the Liliani, Makhan Naik and others were the plaintiff and Mangu and Duna were the defendants. This suit was decreed by order dated 28/8/40 in terms of compromise petition filed by the parties on 17/8/40. In this compromise petition, the Manji brothers, who had taken settlement, had mentioned that they were poor and could not pursue their case, and because initially these Liliani had possession over certain portion of the plot of 1861, hence they fortified the right to 3 bighas 7 kathas, 7 rows of the plaintiff. There is title execution case number 2 of 1941 and the same court number 2 at the same court number 2 at Dumka by order dated 37/41. It appears that possession was delivered. Thus we see that the SDO has proposed eviction of both aliener and alienee from plot 1861 and settled it with the ancestors of the appellant, saying that there were poor people who deserved the settlement. Even in that case, the Laks had wanted to take settlement, and the SDO had reported that the land could not be settled with them as it would amount to re-expiring illegal alienation, repairing illegal alienation, as these were the alienee. What the Laks could not have achieved in SDO court, they are tried to achieve in title suit. It is clear that the poor settlee, Mangur Manji and Duna Manji were found to make compromise as they did not have money to fight the case. And somehow they were frauded into making the compromise. This is my considered opinion. Such fraudulent compromise degree cannot be valid, as this amounted to alienation of land which was validly settled with Mangu and Duna Manji. The Manji under law could not alienate these land, thus this compromise decree is bad in law. Now these findings, my lord. Settlement has been given in 1940 and the act is of 1949. So clearly learned SO has exceeded his jurisdiction by giving this observation that these are fraud and collusive
No, I couldn't get it.
Settlement has been entitled to, it has been given in the year 1940. The act is of 1949. So the eviction of act is of 1949. So clearly learned SO has exceeded his jurisdiction.
So 1949 Act has no application. Prior to 1949, the property could be alienated. ये कहना आपका?
How can this finding be given? I am going to just how this finding.
क्या judgment है उसका क्या नाम है? Full bench. SPT.
हाँ.
अगर 49 के पहले एडवर्स पोजीशन कंफर्म होता है, क्या नाम है उसका? Where is that judgment applying?
Yes. Alumni Hasta.
हाँ, याद
Versus the state of Honorable Justice Application Singh.
नहीं, ये बहुत पुराना जजमेंट है, फुल बेंच का जजमेंट। It's a full bench judgment. आगे पढ़िए. Read further.
ठाकुर है
क्या नाम है?
ठाकुर versus state of Bihar.
Full bench.
19
Yeah. आगे पढ़िए.
In view of the above mentioned discussion, it is clear that both the respondent first and second party.
नहीं एक तो और है ना. The likes cannot claim adverse possession.
The liars cannot claim adverse possession as possession in the title execution case number 2 of 1941 was delivered to them on 37/1941, and hence these persons are their successor and had not perfected their title by 1/11/49 when the Act of 1949 came into force. Regarding the claim of the respondent first party, it is clear that they were validly evicted from plot number 1861 and therefore no claim, therefore
बोराई जी को बुलाइए.
can claim no title to it. In view of the aforementioned discussion, it is clear that both the respondent first and second party have no title over the said plot 1861 upon of plot 1861 of Jamabandi number 71 measuring 6 bigger 19 katta 16 to rightfully belongs to cabinet whose predecessor bought this land by valid settlement and were according to SDO the most deserving rights of the Mausa. Under these circumstances, I find that the learned ASO has earned in judgment dated 12/12/84 in which has completely looked over the said eviction in the eviction case of number 681 of 1938-39. This appeal is therefore allowed and already data passed by ASO in RD case number 59 of 1984 of Manchester status. Furthermore, in view of the aforementioned, there is one more element finding by the learned ASO method. He has given the settlement. He has given the possession of entire land of plot number 1861 to the respondent first party. However, those plots were carved out 1861A and 1861B. 1861A was given to the respondent first party through that eviction proceedings. 1861B was always in the possession of the ancestors of the petitioners.
Which was not the subject matter of dispute.
It was not.
Was it beyond the subject matter of dispute? There is another plot 1861, 61B.
In Jamabandi number 71, my lord, pursuant to eviction of the original rails, my lord, it was carved out at 1861A and 1861B.
From where do you say this?
19 of my lord, page 18.
Page?
18, order of evidence, yes. या उच्छेदी की कार्रवाई जमाबंदी नंबर 71 के हाल तेसरा संख्या धानी दो जमीन के लिए की गई है। इस संबंध में अवैध सरकार ने बताया कि यह जमीन उसके बाप दादा ने हासिल किया। एक उसी समय से जमीन जोत रहे हैं। जमाबंदी रहित ने यह भी स्वीकार किया कि यह अवैध दखलकार लोग बहुत दिन से जोत रहे हैं। इस संबंध में बाद में अवैध दखलकार ने यह बताया कि वे हाल केसरा संख्या 2411, 2418, 2419, 2420 या 2421 की जमीन नहीं जोतते हैं। यह मामला आईई नंबर 57/84 से संबंधित है। यह जमीन अवैध दखलकार ने सत्ववाद संख्या 8/1940 द्वारा प्राप्त किया है। ऐसी परिस्थिति में आरई नंबर 7/84 में पारित आदेश के अनुसार की जमाबंदी नंबर 71 के हाल खेसरा संख्या 24/10, 24/24, 24/25, 24/26, 24/27, 27, धानी एक जमीन का खाता धनेश्वर लायक पिता होरो लायक के नाम से खोले। This was the land of 1641 A.
I do not know. You just said that there are two properties, A and B. Right? Where is it? A and B. 1861A and 1861B. Where is that?
In the order of member learned commissioner, it has transpired. At page number 73.
Yes, read.
This is an appeal against the order dated 19/6/1985 passed by settlement officer Gomka in his missed appeal number 114 of 1985, thereby wherein the SO reversed the order dated 12/12/84 passed by the ASO in RE case number 59 of 1994 and evicted the appellant from part of plot number 1861B of code of Moja Pester PSW. The case of the appellant in brief is that plot number 1861, Jumawali number 71, area 6 Biga, 14 Katta and 16 Dur was jointly recorded in the name of Manager Kumar, son of Kailu Kumar, and Jugal Kumar, son of Nasib Kumar. Coming Ganza settlements, pertaining to Ganza settlement, this Jamabandi corresponds to the McPherson Jamabandi number 46, which belongs to the common ancestors of the appellant and the respondent second party. Jugal Kumar has been evicted from the part of plot number 1861A with an area of 1 bigha 4 dur in EA case number 691 of 1938-39, and it was settled with one Mangru Manji, the ancestor of respondent first party. The rest area 4 bigha 15 katta 12 dur of plot 1861B continued to be in the possession by the ancestors of the appellant after their death by the appellants, which were converted with new plots number 1416, 2024, 2025, 2426 and 2427. Such situation was confirmed subsequently in title suit number 8 of 1914, Martin Nayak and others versus Nehru Manji and others. The settlement authority during the present settlement operation from the possession of the appellants over rest area of 4 bigha, 15 katta and 12 dur, and accordingly recorded their name in the khata. Evicted the respondent first party therefrom and directed the same to be restored to the respondent second party. While order dated 12/12/84 in RE case number 59 of 1984 of the ASO, the respondent first party preferred an appeal before the SO, who in this appeal number 11485 by his order dated 1986-85 allowed the appeal and set aside the order of the ASO and evicted the appellant and respondent second party. The grounds of appeal are that the appellant has been in continuous possession over the area of 4 bigha, 15 katta, 12 dur and paying the rent up to date and thereby
Just a moment. बोले जी वो SPT में 1949 एक्ट का जो आया था सप्लीमेंट्री प्रोविजन, उसमें एडवर्स पोजेशन का था प्रायर टू 12 इयर्स पर, है ना? कौन सा जजमेंट आपके पास होगा, आप देखिएगा। और ये कॉम्प्रोमाइज डिग्री से ट्रांसफ़र नहीं हो सकता SPT में भी, वो दोनों जजमेंट लेके अभी रिसेंटली भी रेफर किए हैं, हमको याद नहीं है। हाँ, यस, कंटिन्यू प्लीज।
respondent first party got the settlement only of 1 bigha 19 katta 4 dur, never possessed more than that area and paid rent only proportionate to the area. They never
Now let us see the finding. heard the parties.
Heard both the parties at length, the plea advanced on behalf of the appellant are that they have been narrated about.
Hmm.
The pleas advanced on behalf of the respondents were that Google had alienated half of its share to one Sutu Pandit and rest half to Gajdat Lai. That eviction case number 681 of 3839, Jugal had been evicted from the entire plot and an order was to settle with the poor renters. That in court of settlement, one Tajib Layak suppressing the fact took settlement and objection filed. Mangru Manji was settled on the entire land, and since then they are possessing the land. And that Rajhar Layak had filed a collusive title suit only to create a document in which decree for itself of that area, but it never came in the possession. Peruse the record of the court below and examine the documentary record on the basis of the following conclusion. First, the whole claim of the appellants is based on contention that his eviction case number 681 of 1938-39 one Jugal had been evicted only from part of plot number 86, but on perusal of the copy of the concerned case record, his contention is proved false. The reality is report dated 1 in 1938 of SN or Deputy Collector that there was an alienation by Jugal and on recommendation dated 7/3/39 of the SPO that both the aliener Jugal Kumar and alienee Sukhtu Pandit, Gajdat Lai and others be evicted from entire land of 1861. The Deputy Commissioner ordered eviction accordingly. In course of settlement of land after eviction, the record proves that by order dated 21/8/39, the LGO had decided to deny settlement with Makhan and Bhuppu Naik, son of Gajdat Lai, because that would have been practically inspired the illegal alienation on which basis the eviction had been ordered and executed. By the order of the same date, one Tanzum Naik was found to be a Jamabandi Naik for 4 annas only, and so the land was settled with him. But while order dated 5/12/39 on a petition against this settlement, the SBO found that Tanzum Naik had fraudulently taken the settlement by showing only one Jama of 4 annas, while he had another Jama also of 8 rupees 4 annas. So the settlement with Tanzum Naik was cancelled and the entire land was settled with Madhur Manji and Dhumar Manji. There appears to be no appeal against this settlement. Hence, the appellant's story, contrary to such situation, is not substantiated. So far as title suit number 8 of 1946 is concerned, the SO in his order examined this case in detail and by a reverse reasoned examination has concluded that this was a collusive document procured by forcing the poor settlers to make a compromise.
Your contention has been considered in detail. What is the error in this order?
My only substance was that a collusive decree, if it is has been obtained by collusion, it cannot be challenged.
Just a moment. It was collusive decree between whom?
Between Mangru Manji, Dhula Manji on the one part.
Just a moment. Mangru and
Mangru Manji, Dhula Manji on the one
Dhula.
part.
And one part with
Makhan Lai.
Makhan Lai. Right? Between them there was a compromise. In title suit number?
8 of 1940.
8 of 1940. Correct?
Subsequently, execution.
Just a moment. Subsequently in execution, the property was restored to
Possession
To whom? Execution case number? Anyways, forget the case number. You just tell me that 1948 है ना, 8 of 1948, 8 of 1946 है, 40 कैसे? यहाँ पे तो 46 लिखा हुआ है पेज नंबर 25 में. अच्छा, एक जगह 1940 लिखा हुआ है, एक जगह 46. So let us take it 1940. Execution case number कितना है?
2 of 1941.
2 of 1941. ठीक है? Okay. The order of the SDO was passed prior to this compromise decree. Okay. Who was evicted by the order of the SDO?
Jugal Kumar.
Jugal Laik is not party in the title suit.
Jugal Kumar has been evicted from the part of.
Jugal Kumar. Jugal Kumar is not the party in title suit. Who was evicted?
Page number 20. Second paragraph.
Yes.
In title suit number 8 of 1914, the court 2 of the deputy collector Junta, the LND marked.
This is title suit of 8 of 1940 is in the court of deputy collector.
Deputy
Collector. Revenue court. टाइटल सूट तो डिसाइड करता ही है रेवेन्यू कोड.
हाँ. Markham Laik and
Others were the plaintiff.
plaintiffs.
And Mangu and Dua were the defendants.
Defendants. In this suit was decreed by order dated 28/8/40 in terms of the compromise petition filed by the parties on 17/8/40. In the compromise petition, the Mansi brothers who had taken settlement and mentioned that they were very poor and could not pursue their case, and because initially they were alienated.
ये मांझी बीच में कहाँ से आ गया? मंगरू मांझी.
Mangu Manji and Dula Manji were the
Yes,
ancestral
yes.
respondents.
Correct.
First parties first.
Yes, yes.
Could not pursue their case, and because initially these alumni had possession over certain portion of this plot 1861, as they forfeited right to 3 Vigha 7 road to the plaintiffs. They are entitled execution case number 2 of 1941 in the same court 2 at Luka by order dated 37/41. It appears that possession was delivered. Thus we see that the SDO had proposed division of both Elena and Eleni from plot number 1861 and settled it with the ancestor of the applicants, saying that
अपीलेंट्स कौन है? मांझीज.
respondents
ठीक.
with the ancestor of the applicant, saying that there was they were who deserved the settlement. Even in that case, the
Laik wanted to
Like
take
had
settlement.
wanted to take settlement, and the SDO had reported that land could not be settled with them, as it would amount to reopening illegal alienation, as there was the what the lights would
So basically what they could not achieve through the title suit, through the SDO court, they got it through the title suit.
Now that
So that order has been illegally satisfied.
there is a settlement, now that order has not been challenged anywhere, my lord, that decree has retained the finality.
Which decree?
That purported collusive. That has attained finality. And in a settlement proceeding that has been set aside, stating that it is my whole intention.
The learned counsel for the petitioner has referred to the judgment passed by Honorable Supreme Court reported in bracket 2014 bracket close 15 SCC 471 and has submitted that even if the title suit number 8 of 1940 was decided by the competent authority, which ended in a compromise, and the same could have been set aside after following procedure of law. However, in another proceeding, the same could not have been declared to be collusive, right? I will not permit you.
I'm sorry.
Right. The arguments have remained inconclusive. Post this case for further hearing tomorrow. कल तो हम लोग का ऑर्डर 41 रूल 11 का कुछ है नहीं, फ्राइडे को तो नहीं रहता है ना, 12 बजे 12:30 डेट्स इसका इतना पढ़ा नहीं रहा ठीक से सीक्वेंस बनाइए और वो जजमेंट पूछ के लेके आइए जो जजमेंट हम बोले, राइट? इनका अपीयरेंस रिकॉर्ड करिए. व्हाट्स योर नेम? कुमार निश्चल.
Nischay.
Nischay.
I will give you.
On the issue of adverse possession.
We'll hear it tomorrow further. State is absent? Nobody appears on behalf of the state.
Perhaps state is not a party.
State is not a party? Private respondent is present. ये जजमेंट पे देख के आइएगा. The law is settled, लेकिन अभी हमारे पास जजमेंट नहीं है.